The latter half of the 20th century saw most American jurisdictions abandon the traditional notion of contributory negligence in favor of the concept of comparative negligence, in which an injured plaintiff is entitled to compensation based on the extent of the defendant's fault for the plaintiff's injury. But comparative negligence quickly came into conflict with the notion of joint and several liability, and the New Mexico Court of Appeals considered that conflict in Bartlett v. New Mexico Welding Supply, which we'll call the company. 3 vehicles were driving in line. The first car pulled into a service station, then immediately pulled back out onto the road in front of Jane Bartlett's car, the second car in line. Bartlett slammed on her brakes and avoided hitting the first car. The company's truck was behind Bartlett, and its driver skidded into Bartlett's car. The driver of the first car was never identified. Bartlett sued the company for negligence, asserting joint and several liability. Because New Mexico courts had recently adopted pure comparative negligence, the jury assessed the comparative liability of everyone involved in the accident. The jury found that Bartlett's damages were $100,000 and that she wasn't at all negligent. The jury further found that the company was 30% at fault for the accident and the unknown driver was 70% at fault. Bartlett moved for judgment against the company for the full $100,000. The trial judge instead ordered a new trial. The Court of Appeals granted the company's application for an interlocutory appeal.